Maybe I don't know. It's just me here, so.
a debt in the ground, or does that mean?
Good morning. Are we recording, Freya?
Yes, we are.
All right, sounds good. I'd like to begin a little early today. We have a lot on the docket. So I'm going to announce
Hold on.
This is the beginning of the.
Mr. Chikalian?
Yes.
Sorry, this is Gerald Ottago, and this is the reporter. I am not quite set up yet. If we give me 1 minute, I should be good to go.
Yeah,
I
Mr.
appreciate it. Sorry
Aragon,
about
when
that.
you're set up, would you let me know?
Yes, sir. All right, ready to go. Thank you so much.
All right, thank you, Mr. Aragon. My name is Gregory Chikalian. It is February 26, 8:54 a.m. This is our second scheduled regular docket. Normally we hear only status conferences today, but we had a few other matters of business to attend to. Let's begin with Select Water Solutions. I'm going to call 3 of the 4 cases separately. 25548, 25547, 25900. Entries of appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean for Select.
Good morning, Ms. Hardy.
Good morning, Mr. Examiner. Miguel Suazo with Beatty Wozniak appearing on behalf of Pilot Water.
Thank you, Mr. Suazo.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Devon Energy Production. And we are no longer objecting to these cases. We have reached an agreement with Select. And I do really like the noir look you are going with the black and white screen.
Thank you, Ms. Vance.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, and we have withdrawn our objections in this case.
Perfect. Thank you, Ms. Hatley.
Mr. Examiner, Matthias Sayer on behalf of Desert Ram, and you know where we stand on this, and we may or may not be a party. I don't think we're a party, but we're here nevertheless, paying attention.
You're welcome, Mr. Sayer. Thank you.
Thank you, sir.
And Mr. Suazo, I trust you got the order on your motion to reconsider. I appreciate your arguments. I carefully considered them before I issued that order. As you know, you always have the right to appeal.
Understood, Mr. Examiner, and we appreciate that. Just wanted to appear for the record today and reiterate our objection and opposition to these cases, but we certainly understand your decision and will assess what our next steps are once the final order is issued.
Perfect. Thank you, Mr. Suazo. Ms. Hardy, it's my understanding that the technical team, the UIC team, requested additional information from you. Has that been submitted?
Yes, Mr. Examiner, it has.
All right. Let's get the technical team on the screen. I see Mr. Harris.
Can you see me, Stacy Sandoval? I'll be the one speaking today.
Good morning, Ms. Sandoval.
Good morning.
Did you get a chance to review the additional information?
Yes, so we reviewed the supplemental exhibit packages and the information provided is sufficient. So these 3 cases can be taken under advisement.
Excellent. Thank you.
One thing I would like to ask Ms. Hardy is to follow up with an email on the delivery status to McCombs Energy Ltd. for case 25900.
Okay, I can do that.
Is that all, Ms. Sandoval?
Yes.
Thank you. Ms. Sandoval, are you going to be the technical examiner for the next case, 25899?
I believe so, me and Tony Harris.
Okay, all right, sounds good. All right, so Miss Hardy, congratulations, and we're off the record in those three cases. Let's move
Thank you
on to
very
case
much.
number. Let's move on to case 4 on our docket, 25899, Select Water Solutions.
Thank you, Mr. Examiner Dana Hardy for Select.
Okay,
Good morning, Mr. Examiner, Dina Bennett on behalf of Coterra Energy Operating, and we have objected to.
sorry, Miss Bennett, unmute yourself, please.
I have unmuted myself, so perhaps Freya might need to unmute me.
Miss
I think
Bennett, I can't hear you, so would you make your microphone louder or get closer or shout, whatever you need to do.
Is that any better? I'm shouting, literally.
So.
Okay, I will try between now and the next case to make my microphone louder, but Dina Bennett on behalf of Coterra Energy Operating, and we objected to this case proceeding by affidavit.
Perfect. Thank you, Miss Bennett.
Miguel Suazo with Beatty and Wozniak appear on behalf of Pilot to renew verbally our objection to this proceeding by affidavit.
Thank you, Mr. Suazo.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Devon Energy Production. And similarly, we are not objecting, just entry of appearance, and we've reached an agreement with Select.
Thank you, Ms. Vance.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, monitoring only.
Thank you, Ms. Hatley.
Mr. Examiner, Matthias Sayer on behalf of Desert Ram.
Thank you, Mr. Sayer. Okay, so Ms. Hardy, when do you want this case to be heard?
I know that Coterra and Select are talking. I think we would request that this be set on the May 12th date to give the parties time.
I didn't understand you. You requesting what?
A contested hearing on May 12th.
Oh, May 12th. Okay.
Yes.
Freya, is that a date that you sent out?
It's not a date that I sent out, but I believe Ms. Hardy requested some later dates as options, and I provided that date.
Ms. Hardy, when was this case filed?
This case was filed, let me just double check. This application was filed January 6th.
Oh, okay. All right. Ms. Bennett?
Mr. Hearing Examiner, the division had already set this case for a contested hearing on March 24th.
Oh.
And I have been coordinating with Coterra, and they are available that date. I'm not suggesting that they would not prefer a later date. I just have not had a chance to coordinate with them about any later dates. So I'm imagining that all parties would benefit from a later hearing date, but I haven't had a chance to even address that with them because I was under the impression that the case was set for March 24th.
Ms. Hardy?
So this application has not been set for hearing previously. We had a prior iteration of this application that was dismissed, and then this was refiled to change the well location. So this one has not been previously set, I don't believe, but I think the May date would allow the parties to communicate and potentially resolve the matter.
Okay.
The March date does not work for Select.
Okay. Well, thank you, Ms. Bennett. Thank you, Ms. Hardy. So, Ms. Hardy, if we set this out to May 12, that'll be the final setting.
That's fine. Understood.
There won't be any continuances.
Okay, that's fine.
All right. So, Freya, do you have any information about a pre-hearing order for March 24?
I don't see that we set a contested hearing on March 24. I'm looking in imaging.
Mr.
Maybe
Hearing
we just
Examiner.
Yes.
This is Dina Bennett. At the last hearing, there was an email that said the expectation was that this case would be set for March 24th. And
Okay.
like I said, I'm fine with, initially fine with it being set for May 12th, but if my witnesses aren't available for May
Right.
12th, I would hope that that would not be prejudicial and we would be able to work on a different hearing date
Of
because
course.
I have coordinated extensively with Coterra about the March
Okay.
24th hearing date.
All right, Ms. Bennett, that's fair. So Freya, wasn't there a date in April also that you had available?
It was April 25th, April 21st.
All right, so so here's what we'll do, Ms. Hardy. I'll honor your May 12 request, but if Ms. Bennett's witnesses are not available for May 12, then we're going to offer you the alternative, which is what you just heard, April 21st.
That is fine. Thank you.
All right, so Ms. Bennett, when will you be able to let the division know?
I'm emailing Coterra right now, but
Sure.
they do have quite a technical team that's going to be involved. And so
Okay.
it may take a couple of days to find out the information. So I'd like at least through Monday or Tuesday of next week to confirm.
Ms. Hardy, Tuesday is the close of business. You can confer with Ms. Bennett and either agree on May 12 or April 21st?
That's fine. And I thought the date in April was the 24th. Is it the 21st?
I don't know. Ms.
Just want to make
Freya?
sure I have the date right.
It's the 21st.
21st. Okay, thank you.
Okay, so Freya, will you do a calendar reminder for Tuesday close of business so that we can issue a pre-hearing order for either May 12, that's the first option, and a backup would be April 21st?
Yes.
All right. Anything further, Ms. Bennett?
No, thank you.
All right, thank you. Ms. Hardy?
No, thank you very much.
All right, sounds good. Ms. Sandoval, I don't know if you're still on, but if you are, do you have any other questions for Ms. Hardy at this time?
No, I do not.
All right. Okay, we're off the record in this case. Thank you. Let's move on to Milestone Environmental Services 25801.
Mr. Examiner, Dana Hardy for Milestone.
Thank you.
Mr. Examiner, Carrie Hatley, entering reports for COG, and we have
Perfect.
objected in this case.
You said you have objected.
Yes, COG operating, and we
perfect.
have entered an objection.
Excellent. Is there a nature of your objection?
We have concerns about the increased injection rate, and we're working with Milestone on an agreement, but we haven't come to acceptable terms yet, but we hope to.
Oh, so you're negotiating now. Okay. Ms. Hardy?
Mr. Examiner, because the parties are working out these technical issues, it's an injection well, and I think I'm optimistic cautiously that the issues can be resolved. I would propose to set this case for another status conference on March 19th.
Okay. I don't have a problem with that. By that time, though, I'll be looking to set it for a hearing or something, or maybe withdrawal of objection if that's appropriate.
Understood. Thank you.
All right. Anything else, Ms. Hartley?
Nope, thank you, sir.
Ms. Hardy?
Nope, thank you.
Off the record in case number 5 on our docket. Let's move to 6 on our docket. Mewbourne Oil 25746.
Dana Hardy on behalf of Mewbourne.
Thank you.
This is Dina. I'm trying to join by my phone so you can hear me better.
I can hear you. So Dina Bennett?
Yes, and I'm here on behalf of Avant.
And
And
did you
Avant.
object?
Yes, Avant originally objected to this case proceeding by affidavit, but it's my understanding that the parties are in discussions and those discussions have been fruitful, or are being fruitful. And I have not withdrawn my objection yet, but I am hopeful that Ms. Hardy has a little more information to provide on that, the status of the negotiations.
All right. Thank you, Ms. Bennett.
Mr. Examiner, Carrie Hatley, entering her appearance on behalf of Marathon Oil Permian, and we are just monitoring.
Monitoring. Thank you. So Ms. Hardy, what do you know about the negotiations?
I know that there are negotiations occurring. Mewbourne has requested or would like to request this case go ahead and be set for a contested hearing on March 24th. I think hopefully the issues can be resolved by then, but if not, they're prepared to proceed.
Okay. Do you know what the nature of the objection is?
I do,
I-
Mr. Examiner, I can help with that.
Ms. Hardy, do you mind?
No, that's fine.
Go ahead, Ms. Bennett.
Avant has planned or was planning to counter propose, and so they would be proposing their own development across portions of the acreage that Mewburn is proposing to develop.
Do you know what percentage of interest Avant owns in this area?
I don't.
Ms. Hardy, do you know how much ownership Mewborn has?
I don't know that I do. I could get that, but it would take me a few minutes.
That's okay. Okay, I understand. So Ms. Bennett, are you saying that Avant is preparing proposals, well proposals?
They were, but I was under the impression that the negotiations with Mewburn had proceeded much further along than Ms. Hardy is. And so I was actually thinking that Avant was almost going to be in a place where they could withdraw their objection and the case not even go to a contested hearing. So I'm frankly a bit taken aback by the fact that Mewburn would want to set this for a contested hearing when that is not what I understood at all. Avant was perhaps is much more optimistic than Mewburn is at the moment, and does not think that there is any need to set this for a contested hearing, much less a contested hearing on March 24th. At best, Avant would, and I understand that you will give preference to Mewburn in this, but if the negotiations are not as far as along as Ms. Hardy is anticipating, then Avant would need to counter propose, and we would need to file competing applications. So March 24th is not workable for a contested hearing.
Okay, how about we do this? Since the parties don't seem to be certain on several key issues here, I'd like to come back to this case and go in recess on this case until after we hear the NOVs on line 26, but before the Longfellow Energy case on line 27. So I'm going to recall this case to give Ms. Hardy and Ms. Bennett some time to communicate with their clients and give me some more information. I would like to know the ownership interest for both parties in this affected lands, and I'd like to know how far along, how positive these negotiations are.
Sounds good. Thank you very much
All
for
right,
that.
so we're in recess on this case, but we are going to come back to that case. Let's move on to number 7 on the docket. This is Permian Resources. It looks like it's joined with several cases, 25818, 19, and 20. Entries of appearance, please.
Dana Hardy on behalf of Permian Resources.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating. And
Thank
we
you.
have objected to the cases proceeding by
Perfect.
affidavit.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company, and we are just monitoring.
Oh, thank you. Thank you, Ms. Vance.
Good morning, Mr. Examiner. One more entry, please. Carrie Hatley
Yeah.
entering her appearance on behalf of Marathon Oil Permian. I'm entering it orally for now, but we'll file it today, and I will be monitoring only.
Monitoring only. Thank you, Ms. Hatley. Back to you, Ms. Bennett, representing Coterra. You've objected. Do you know why?
Yes, Mr. Hearing Examiner. Coterra is objecting because Permian's proposal development plan proposes to develop acreage that is under a JOA that is controlled by Coterra. And so this is a case where Coterra has the desire to develop its own acreage and feels strongly that it should be allowed to without interference from Permian. And also, this case is currently set for a contested hearing on May 12th. So I looked back through the transcript to see why we were coming back for a status conference today, and it wasn't immediately clear to me, but this case is set for a contested hearing on May 12th.
Good, that's helpful. Thank you, Ms. Bennett. Ms. Hardy?
Thank you. The case is set for contested hearing on May 12th, and at this point, we would just plan to proceed to hearing on that date.
Okay. All right, so we won't have any further status conferences unless the parties let the division know that they don't want the contested hearing on May 12th, and that they want to have a hearing by affidavit, or they're dismissing their cases. So anything further, Ms. Bennett?
Nothing further from me. Thank you very much.
All right, Ms. Hardy?
No, thank you.
All right, and Ms. Hardy, before I go move on from these 3 cases, you said this case is set. Did you mean these cases are set?
Yes, thank you. All three of them.
Just wanted to make sure I was following the conversation. Thank you. Okay, we're off the record in those cases. Let's move on to Mewborn Oil. It looks like there's two cases here, 25851 and 52.
Mr. Examiner, Jim Bruce, representing Newbern.
Thank you.
Good morning, Mr. Examiner. Ben Holliday entering appearance on behalf of COG Operating and Concho Oil and Gas.
Good morning, Mr. Holliday. Did you object?
Yes, we objected in this case.
Why?
Competing development plans.
Oh.
We intend to file competing applications probably this week.
Oh, so you've already sent out the proposals a few weeks ago.
I believe so, yes, sir.
Okay, perfect. And you're representing ConocoPhillips?
Yes, through their entities, COG Operating and Concho Oil and Gas.
Okay, very good. I understand. All right. Thank you, Mr. Holliday. Mr. Bruce.
I think the matters just need to be set for a contested hearing. I'm not sure what's available, but Lady Earl sometime in May.
Okay, well, let's check. I'm going to give you preference, Mr. Bruce, since they're your cases filed earlier than Mr. Holliday's, but is that the soonest you want to have it is May?
Or April.
Okay, April or May. Freya, is it April 21st or May 12? Or those are dates in May, in April and May?
It's April 21st. We can also do April 28th.
Oh, okay. And then May 12.
Correct.
All right, very good. Mr. Holliday, a preference for you?
I think we prefer the later date, although I'm looking at the calendar, that 12th and 13th might not work because I know myself and Miss Ryan will be involved in the Foundation for Energy Law conference there. We'll be in Santa Fe,
Right.
but we might be a little tied up doing that thing. So I would say maybe I need to confer with Ms. Hatley, but for now, I would say the 28th would probably be the best.
Right. Okay. And then when you say Miss Hatley, do you mean Mr. Bruce?
I mean, sorry, Ms. Hatley on behalf to gauge COG's availability and for the 28th date.
Okay. Well, Mr. Bruce, does the 28th of April work for you?
Yeah, I will check today with availability.
All right. Well, I'd like Mr. Holliday and Mr. Bruce to check now with their clients and whoever else they need to check with, and we'll come back at the end of our docket and find out, do you prefer the 28th or maybe even the 21st? But those are the three dates we can offer you, April 21, 28, or May 12. And I understand why May 12 is not the best for you, Mr. Holliday, because I'll be at that conference as well. So we're going to come back to these two cases to get the availability. So we're in recess on those two cases. Let's go to Spur Energy Partners, 25854.
Dana Hardy with Hardy McLean on behalf of Spur.
Thank you.
Good morning,
Good
Mr.
morning,
Examiner.
Oh, go ahead.
Miguel Suazo with Bidding Wozniak appearing on behalf of Hillcore Energy.
Okay, and did you object?
We did.
Okay, why?
As I understand it, the wells that are being proposed are horizontal, and Hillcore has some vertical wells in the vicinity that they're concerned may be impacted.
So that sounds like a negotiation that's ongoing to fix that, right?
That's correct. The parties have confirmed that they are in discussions. I don't think they've quite reached any sort of agreement just yet. Hillcore is not going to be submitting competing applications, so I'm hopeful that we're going to be able to resolve this otherwise.
Okay, and Ms. Kessler?
Good morning, Mr. Examiner. Jordan Kessler on behalf of POG Resources, and we are just monitoring this.
Thank you, Ms. Kessler. So, Ms. Hardy, it sounds like this sounds like something that can be negotiated. Do you agree?
I know the parties are negotiating. We do have a contested hearing set on March 24th.
Okay.
So at this point, we would like to keep that hearing date.
Right. Okay.
And of course, if the parties reach an agreement, we will not need it.
Right. Anything further, Mr. Suazo?
No, thank you.
Thank you. Ms. Hardy?
No, thank you.
All right, thank you very much. Mewbourne Oil cases, 25860-6263.
Yes, good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of Mewbourne Oil.
Good morning, Ms. Starnes.
Good morning, Mr. Hearing Examiner. Darren Savage with Aberdeen Shield, appearing on behalf of WPX Energy Permian LLC.
Good morning, Mr. Savage. Can you tell me if you objected?
We did an entry of appearance and we're currently in negotiations, but we plan to file competing applications.
Oh, so you definitely objected.
Well, technically we didn't object because the Permian Resources objected, as I understand, but we do object to this.
Okay. And you're considering competing applications? In other words, have you sent out proposals?
We sent out the proposal on February 9th.
Oh.
And yeah, we'll be drafting applications and filing those. We would like to set a contested hearing date.
Okay, understood. And do we have a Ms. Hardy?
Mr. Examiner, yes, for Permian Resources.
Thank you. Did you object?
We did object.
What's the purpose of your objection?
Permian Resources and Mewbourne are in discussions regarding this acreage and working on negotiated terms. We would be fine with another status conference in March, which is what I had discussed with Ms. Starnes. But I wasn't aware that WPX was filing competing applications.
Okay, let's go back to Ms. Starnes. When did you file these cases?
We filed these cases, I believe, either in December or January.
Can you look for me?
Yes, sir. Let me do that right now.
Thank you.
Mr. Hearing Examiner, if I may add,
yes,
we would be we'd be happy with another status conference while we're preparing for our competing applications and also negotiating with the parties.
Right. Okay, perfect. Thank you, Mr. Savage.
Okay, actually, it looks like we filed these in November.
In November. All
yes,
right.
sir.
Okay, so Ms. Starnes, I'm okay with setting these for another status conference in March, but I'm going to keep these on somewhat of a short leash. So you should be prepared to come to a contested hearing. If negotiations aren't finished by March, you should be prepared. And I would say that you have some dates here to consider.
Okay.
You have April 21st, you have April 28th, and you have May 12th. And those are some dates to consider.
Okay, perfect. I will speak with Mewbourne about that, and hopefully we will have some fruitful updates in March.
All right, so let's see, status conference in March, and then dates April, May. Anything else, Mr. Savage?
Yes. So we did our well proposal on February 9th. We will need the 30 days for negotiation and file the application somewhere around March 11th. And then we need 20 days for notice. And so that March 12th looks like the ideal date for us to satisfy all the filing and the notice requirements for the competing applications.
You mean May 12th?
Hold on, Ms. Starnes. I want to make sure I understand, Mr. Savage. Would you repeat that, Mr. Savage?
Yes, sir. Our well proposals went out February 9th. Guidelines of the OCD is that they prefer a 30-day grace period before we're allowed to file the applications. That would be somewhere around March 11th to meet the deadline for the applications. Then after the applications are filed, we would need sufficient time for notice letters and notice publication. So it looks like the May 12th would be the ideal date to satisfy all those criteria.
Okay. Well, I'm just throwing out some dates for Ms. Starnes and you to negotiate over if your other negotiations are not fruitful. so that when we come back in March for a status conference, you can tell me May 12 or April 28 or whatever you want.
Okay.
But I do understand your timing, Mr. Savage.
Okay, thank you. I just wanted to get that noted.
Okay.
Thank you.
Ms. Starnes, anything further?
Nope.
All right. So, Ms. Starnes, our second date, our second date in March. Freya, when is the status conference docket in March?
On the 19th.
19th. So, Ms. Starnes, would you continue your cases for the 19th of March?
Yes, absolutely.
All right, perfect. Ms. Hardy, was there anything?
No, thank you.
All right, you're welcome. Okay. Thank you. We're off the record in those three
Thank you.
cases. Let's move on now to Taprock operating 25886, 25887.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak appearing on behalf of Taprock Operating.
Thank you.
And Mr. Examiner, Dana Hardy with Hardy McLean on behalf of COG Operating.
And your position?
We have objected to these cases and are planning to file competing applications.
Oh, okay. When were the proposals sent out?
Proposals have gone out this week, is my
Okay.
understanding. And so we would then file our applications in time for the May docket. It would be
Okay.
the May docket. So I would propose a contested hearing on the May 12th date.
Okay. I understand. Anything further, Ms. Hardy?
No.
All right. Mr. Suazo, how do you want to proceed now that you know what's going on?
Sure. Well, we haven't received the proposals yet, but we'll be on the lookout for them. But
Okay.
otherwise, Taprock does not have any objection to the May date for the contested hearing.
All right. All right. So what we'll do is we'll do a May 12 pre-hearing order for contested hearing. And Ms. Hardy, once you do file your, the usual, please let us know so we can consolidate.
Yes, thank you. I will do that.
Now, would the parties think maybe in April, and I'm not saying you need to, but would the parties want an April status conference, or do you want to just advise the division if things change?
I think I'd be okay with an April status conference. If anything changes, obviously we can let the division, but I think that could be helpful under the circumstances, especially because we have not yet seen the proposals and applications. And so I think it might be wise to get something on the calendar.
Okay. Ms. Hardy?
That's fine with me, Mr. Examiner.
All right. All right. So then, Freya, when is the April status conference docket?
On April 16th.
April 16. All right. Thank you. All right. So, Ms. Hardy, if you would continue these cases to April 16 for a final status conference, we'll issue a pre-hearing order for May 12.
Thank you. And since these are these are actually Taprock's cases, I suppose they would file the motion for continuance and then we would.
That's what I meant. Thank you.
We can do that.
Ms. Hardy, you've had so many cases so far. I'm just used to your filing the continuances, but thank you for correcting me.
It's a busy
And I
day,
apologize, Mr. Suazo. Anything further, Mr. Suazo?
No, Mr. Examiner. Thank you.
All right. We're off the record in those two cases. Let's move on to Powderhorn Operating 25888.
Mr. Examiner, Dana Hardy with Hardy McLean for Powderhorn.
Thank you.
Mr. Examiner, Matthias Sayer on behalf of EOG.
Thank you.
I should note we did object to the cases moving forward by affidavit.
And what's the purpose of the objection?
EOG, it has a number of concerns, but most prominent is concern about stranded acreage. And that's their primary concern. The secondary concern. They do have a well in the vicinity, and so some concern about collision issues.
Do you think those concerns could be negotiated?
Yeah, that is the hope and intent.
Okay, I thought so. All right, thank you.
Caitlin Locke appearing for Waterloo Resources and WR Non-Op.
Okay. Good morning. Did you object?
Yes, Mr. Examiner, we objected on the basis that Waterloo did send out competing well proposals. We dismissed our application in the hopes of working out a deal, but there's still concerns that we have about Powderhorn's development plans at this point in time.
So is that something that can be negotiated?
It's something that Waterloo is continuing to work on currently.
Okay. And then Ms. Vance?
Oh, I am so sorry. I did not realize we were already on the Powderhorn case, so my apologies.
We're moving along, Ms. Vance.
Yeah, moving very quickly, moving at a clip. Okay, so good morning, Mr. Hearing
Morning.
Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Oxy One or Y1 Company, and we've just entered an appearance and just observing for Oxy, and then also for MRC Delaware Resources LLC, and we have entered an appearance and objected. And I did just send Ms. Hardy an email this morning regarding Matador's position, to provide some color on the objection. So happy to share that if everyone else has gone. Okay.
Yes, please.
So, okay. So Matador would like to request another status conference. That being said, Matador is preparing counter proposals, and they have not sent those out yet, but are planning to do so. So again, the thought is to start with another status conference and see where things go from there. It is my understanding that Matador and Powderhorn have been in discussions, and they may need some more additional time. So.
Okay. Ms. Hardy?
Mr. Examiner, Powderhorn controls more than 50% of the interest in this acreage and sent out its proposals in November, would like to proceed with its development, and would request a contested hearing date as soon as possible.
Okay. I'll give you a contested hearing as soon as possible, but with Matador's counter proposals, when will they be sent out, Miss Vance?
So my understanding is that they're being prepared right now. Hopefully they would go out and I can touch base with Matador, but I believe, maybe within the next week or so, which means even if we sent them out today, we wouldn't be, the case, their case would not be ripe until the end of April. So I think that the May 12th date that was previously floated in terms of contested hearing dates would be the soonest we'd be ready. Or the case would be ripe.
And by that point, Powderhorn's case is 6 months old at that point. And, I do get concerned when parties wait that long to send out counter proposals, but, I don't have the authority to do anything about that. It's just disappointing. So Ms. Hardy, if you want, what I can do is issue a pre-hearing order for this case for May 12. I don't know what else I can do for you.
Mr. Examiner, would it be possible, well, just thinking through the dates, I mean, Matador may not need to wait the full 30 days to file its pooling application after it sends the proposals. Seems like that could be an option in terms of a setting in late April. That's one possibility I would raise.
I mean, I can save you a few days by doing that, but it's not, April 28 is, I guess, 2 weeks before approximately. If that would help you out, then I can do April 28 for you and we won't use the full 30 days. Ms. Vance?
Obviously, we would like to make sure that we're fulfilling the requirements under the rules. I do understand there's a little bit of room on the time between sending out proposals and filing our application. But again, I am not sure exactly when our proposals are going to go out. I don't want to, give a false impression here. So our comfort really is with the May 12th date. So.
Well, it's Ms. Hardy's case, as you know, and this case has been filed in November, which means that your client got the proposals a month before, approximately. I'm not sure what the delay is.
Mr. Examiner, I think I actually have a conflict with the April 28th date, so I could do April 21st or May 12th.
We definitely would, yeah, the May 12th. We don't want to go the other direction.
Right.
Mr. Examiner, quick question. Were these filed in November or January?
I don't know. Ms. Hardy said
Yeah.
November. I don't know.
Yeah, I was going to say they were filed May 5th or January 5th.
Right,
Oh.
the proposals were sent in November, but the
Ah.
application was filed in January. That's correct.
Okay.
Because my just comment on that is, while EOG is not intending to, file proposals, we hope to have meaningful conversations with Powderhorn, but to date have heard very little from Powderhorn. So, for what it's worth, if we're looking at contested cases, we would prefer the May date as well.
Yeah, so Ms. Hardy, knowing that these were filed just last month makes me feel much better about May 12. So we'll issue a pre-hearing order for May 12. Good luck with the negotiations and the counter proposals. And Ms. Vance, if you do file applications, please let the division know so we can consolidate.
Perfect. Thank you.
You're welcome. We're off the record in that case. Let's move on to Avant Operating 25890.
Morning, Mr. Examiner. Caitlin Locke appearing for Avant Operating.
Good morning.
Mr. Examiner, Matthias Sayer on behalf of EOG. And
If
we
you
did
could
file
tell me of your position.
Yeah, and we did file an objection.
Okay.
EOG has concerns. In this case, we do have a well in the section and have legitimate concerns about collision. And so that's the nature of our objection.
Okay. All right. Ms. Luck, when was this filed?
Sorry, let me pull it up. This was one that was filed by Ms. Bennett's office.
Sure.
It looks like it was filed on January 5th.
January 6th. Perfect. Thank you.
Excuse
so,
me,
Ms. Luck,
5th.
how do you want to proceed?
Avant would like to have a contested hearing scheduled at this point in time. If the April 21st hearing date is available, that would be great. But if there's a later date, that's also fine.
I think the April 21st date is available. Mr. Sayer, does that give your client enough time to negotiate?
In conversations with my client, they would definitely prefer the May date.
Okay. I do give the applicant the benefit of the doubt when it comes to dates. I guess if your client and Ms. Luck's client, reach an agreement, you can let us know if you need time to reduce that to a writing, but I'm going to honor Ms. Luck's request for April 21st at this time. Anything further, Ms. Luck?
No, thank you.
All right. We're off the record in that case. Let's take a 5-minute break before we go on to Chevron USA. We're off the record. Thank you. All right, we're back on the record. It is 9:42 a.m. and I'm calling Chevron USA 25878.
Good morning, Mr. Examiner, Dina Bennett on behalf of Chevron USA.
Thank you, Ms. Bennett.
Mr. Examiner Dana Hardy on behalf of PBEX and EGL.
Thank you, Ms. Hardy. So we were set for a motion hearing and status conference, and Ms. Bennett, I assume you're standing in for Mr. DeBrine?
I am, thank you.
All right, perfect. Did you receive the order that was issued?
I did, thank you very much.
All right. Okay, so I'd like to set this for an evidentiary hearing. And as it is your case, Ms. Bennett, when would you like to do that?
Thank you. I saw that the proposed dates are March 24th and April 21st. And I've emailed Chevron about both of those dates, and I've heard back from one person on the team, but not the full team yet, that either of those dates work. But I still do need to hear back from the whole team. So I just sent another email hoping to get more information for you. But as of this particular moment, both dates appear to work for Chevron.
All right. And Ms. Hardy?
Mr. Examiner, we are going to need to conduct discovery.
Okay.
We are going to need to subpoena from Chevron
Okay.
based on documents. All proposals they've received under orders for the past 3 years, proposals sent out for the past 3 years. We may need to take depositions. So I think they're saying they didn't understand they needed to pay well costs. I think that's fair game given the issues they've raised, and they submitted additional documents with their response that we haven't seen before. So I think that's going to be critical given the issues in this case. So once we receive that information, I would like to file a motion for summary judgment on waiver, because I think that by electing to participate, they waived arguments regarding estimated well cost and the proposal letter. And I know the division issued an order yesterday in an XTO case denying reopening a case on the ground electing to participate was a waiver of hearing notice. So at least that's my understanding of part of that ruling. So if that's the case, then certainly electing to participate under a proposal letter, any objection to the, and so that's another legal motion I would like to file. And I think it's important for the division because the implications in this case are really significant. I think, allowing operators to reopen cooling orders because they failed to elect to participate, because once they've elected to participate and then just didn't pay their well cost, that's a slippery slope that's going to involve many, many, many pooling orders. So I think it needs to be thoroughly vetted and considered by the division. And so I would request at the earliest a contested hearing on the May 12th docket.
So let me think about what you've said before I go back to Ms. Bennett. In the order that was issued yesterday in the XTO Riley matters, 3 of the 4, the issue was notice and whether sufficient notice was given to XTO. And I found that it had been, in part based on the election, but that wasn't the critical issue for me. It was part of the issue, but it wasn't the critical issue for me. I see this case as a different case, as all cases are different based on the facts, and we don't know a lot of the facts yet. What we do know is that I agree with Chevron that it has standing to move forward with the case to a contested hearing. Now you're talking about additional discovery and depositions. And I think it's important for us to agree on what are the issues to be heard at the contested hearing. Maybe today is not the day for that. If there's going to be a full-blown argument about the issues at the hearing, I think we need to do this at a later date, after the parties discuss things a little further. Ms. Bennett, that's my thinking so far. What do you have to say?
Thank you, Mr. Examiner. I obviously I disagree with Ms. Hardy that additional discovery is required. This is about a issue between Chevron and PBEX, and PBEX and EGL have plenty of examples, I'm sure, of proposal letters that they could refer to without undertaking additional discovery. But I do agree with you that at this particular moment, either we should set a contested hearing on the dates that you proposed, or we should come back for a status conference on March 19th after Ms. Hardy and we have had a chance to outline the issues, and then set a contested hearing date for that. I would strongly disagree to any further motion practice, though. Ms. Hardy, or PBEX, had its opportunity to challenge Chevron's ability to proceed in this case, and they have not done so other than to challenge Chevron's standing. And this seems like if we're caught in a loop of motion practice, we're never going to get to the fundamental issues here. And whether waiver occurred or not, which I disagree with, can be an issue that's addressed at the hearing on the merits. So bottom line, I think we should either set it for a contested hearing today, or as a approach to streamline the issues for the division, set it for a status conference on March 19th with this contested hearing to come shortly thereafter.
So what I'd like to do is this. I think it's fundamental to understand what the issues are moving forward. I thought I understood the issues, Ms. Hardy, but I'm not sure I do after what you said a moment ago. And I want both parties to have a full and fair opportunity to present their case. That's the part of the rationale behind the argument, behind the case law that supports standing for Chevron. But it's also, I don't want to cut off Ms. Hardy's ability to present a full and fair case. So that being said, I don't want to wait till March 19 to understand the issues. I should understand the issues now or in the very near future, because if I understand the issues more clearly and if parties are able to agree on the issues, then discovery or any additional discovery will be self-evident and will be easy, and we don't have to fight over every little thing in discovery. So here's what I'd like to do. I want to look at a calendar now, and with Freya's help and Ms. Hardy and Ms. Bennett, I want to set a, we can call it a status conference, it's fine, or a scheduling conference. Maybe we'll call it a scheduling conference, where we can lay out the timeline between the resolution of the issues to the contested hearing. So let's call it a scheduling conference. And I want the parties to have time to talk amongst themselves as well. I think that's the best way to get to a resolution on at least the issues. When would be the soonest date? I'm going to go with you, Ms. Bennett, because it's your case, and I know you want a hearing sooner than later. When is the soonest you feel like the parties can confer on the issues alone and possibly discovery, the scope of discovery? What date can we come back for a scheduling conference?
Would March 9th be a possibility?
Well, the 10th, March 9th. March 9th is difficult for me, but I'd be willing to do it because I think this case needs to move forward. Ms. Hardy, March 9th, does that work for you?
That would work for me. Or we could do it on March 10th, because we do have the contested hearing docket on March 10th that I have a case on that docket, so I will be present.
Ms. Bennett, does that work for you, Ms. Bennett?
Yes, March 10th is totally fine. I was just trying to pick a date that was far enough out, but was not too far out.
Okay, so we're going to hold a scheduling conference March 10. We're going to do it at the very beginning. It's going to be the first case that we hear that day, because I don't expect that it's going to take very long to at least understand the issues for the contested hearing, and then any additional discovery that the parties feel like they need. Now, whether they need a subpoena or not, we don't know yet. But at least let's agree on what the issues are moving forward. So Miss Bennett, it is your case. Please continue it. Now, I don't know, Freya, do you know, we already have a docket that day, March 10th, so it's easy to continue it to that day.
Sounds good. I'll do that.
All right, sounds good. Miss Hardy, does that work for you?
It does. And Mr. Examiner, I was planning to send out a subpoena request to, well, I would submit it, of course, to the division and then to Chevron next week.
Mhm.
So I just wanted to mention that. I could wait until the status conference.
I think it'd be helpful, Miss Hardy, because by narrowing down the issues at the hearing, it also narrows down the discovery that's necessary.
Okay. Thank you.
Anything else, Miss Hardy?
No, thank you.
Okay, anything else, Miss Bennett?
No, thank you very much.
All right, sounds good. Well, thank you both. We're off the record in that case. Let's move on to the WPX Energy Permian cases. We have John Garcia, who is our technical examiner today. These are case numbers 25893, 9697.
Yes, Your Honor. William Zimsky with Abity and Schill on behalf of WPX Energy Permian LLC.
Good morning, Mr. Zimsky. Please
Good
proceed.
morning. Yes, today with me are WPX's landman, Tim Prout, who has testified previously before the division.
Okay.
His credentials have been accepted as an expert witness in petroleum land matters. Also with me is WPX's geologist, Russell Gooden, who has testified previously before the division as an expert witness in geology, and his credentials have been accepted as a matter of record. In case number 25893, WPX seeks a pulling order for all uncommitted interests in the Bone Spring Formation, designated as an oil pool, underlying a standard 430.41 acre, more or less, spacing unit comprised of the east half of sections 26 and 35, Township 26 South, Range 29 East in Eddy County. The unit will be dedicated to the Steel Guitar 26-35 FedCom wells as 3 initial wells. Now, WPX previously pulled and received a pulling order for the proposed horizontal spacing unit in case number 25611. And WPX is now seeking a new pulling order to supplement and replace order number 24068. WPX has changed its development plan to propose 2 U-turn wells, the 324H and the 334H, in addition to the standard lateral for the 333H well. In case number 25611, WPX proposed the 324H, the 325H, the 333H, the 334H, and the 335H wells. In this case, the 333H well is essentially the same as the 333H well proposed in case number 25611. The new well, the new 1 U-turn well is the 324H U-turn well in this case, and that replaces the 324H well and the 325H well proposed in case number 25611. And the new 334 U-turn well replaces the 334H and the 335H also proposed in case number 25611. Orientation of the wells in unit are stand up north to south. Now the location of the Steel Guitar 333H well is non-standard. The division has approved the non-standard location for this well on January 26, 2026 by Administrative Order NSL 9175. Mr. Prout's Exhibit A for this case includes his landman self-affirmed statement, 3C102 forms, an ownership breakdown, well-proposed letter with AFE, the chronology of contacts, and the notice provided to the uncommitted owners. Mr. Gooden's Exhibit B for this case includes his self-affirmed statement along with 5 standard geology exhibits showing the potential for development of the unit as described in his statement. Exhibit C provides my self-affirmed statement for notice of mailings and publication notice. Notice was timely mailed on January 13th, 2026. Notice by publication was timely published on January 15th, 2026 to account for any unforeseen circumstances. We did amend the hearing packet to send out letters to 7 parties who had not received them when this case was first scheduled. And we amended the landman statement to refer to amended exhibits A2 and A5. Amended exhibit A2 updates the addresses of the 7 parties. Amended exhibit A5 states the notice letters were originally mailed on January 13, 2026 were again mailed on February 10th, 2026 to 7 parties with updated addresses and to 1 party whose letter was lost in the mail. And the amended exhibit C reflects that same information. Amended exhibit C2 includes information on the second notice hearing mailed to the 7 parties with updated addresses and the 1 party whose letter had been lost. At this time, I move for that exhibits A, B, and C and all sub-exhibits be admitted into the record for case 25893 and that the case be taken under advisement. Myself and the witnesses are available for questions. Thank you.
Admitted without exception. Mr. Garcia, do you have questions for any of the witnesses?
No questions.
Okay, can we take them under advisement?
We can.
Thank you, Mr. Zimsky.
Okay, now in case 25896, WPX seeks an order pulling all uncommitted interests in the Wolf Camp Formation designated as a
Mr.
gas
Zimsky,
pool. Yes.
Let me interrupt you just for a moment.
Okay.
I'm admitting all exhibits in all 3 cases into evidence. I'm going to ask Mr. Garcia. Mr. Garcia, do you have any questions on any of the 3 cases?
I do not.
That's what I thought. So, Mr. Zimsky, all 3 cases are taken under advisement.
Okay, in your Mr. Hearing Examiner, WPX is trying to get these wells drilled as quickly as possible. I think that's in the OCD public policy to produce oil and gas as quickly as possible. They have the rig scheduled for March 20th, and I would ask the indulgence of the division. I know you guys are slammed and you're very busy, but it would be really appreciated if these orders could issue, since we've already had the orders issued previously, that they could be issued a little bit more expeditiously than normal. And I understand, I'm begging the indulgence of the division in this request.
All right, Mrs. Zimsky, we'll take it under advisement.
Thank you.
Thank you, sir. We're off the record in those 3 cases. Let's go to Admiral Permian Operating 25709.
Mr. Examiner Dana Hardy for Admiral.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company. And we are just monitoring. We previously had an objection in one of the cases, well, both of the cases, and we have since withdrawn those.
Okay, thank you, Ms. Vance.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of ConocoPhillips, monitoring only.
Perfect. Thank you, Ms. Hatley. Okay, Ms. Hardy, go right ahead.
Thank you. This case was heard on the February 5th docket, and we're back for supplemental information. We did file that timely, and unless there are questions, I would request that our supplemental exhibits be admitted into the record and that the case be taken under advisement.
Perfect. Thank you, Ms. Hardy. Your exhibits are admitted without exception. And I know Mr. Garcia has questions. I'm not sure which witness.
The landman. I believe it's
Ms. Hardy, would you call your landman?
Yes, let me see if Mr. Hall is traveling, and so if he's not, I don't know if he's available or if he's on. If he's not, we have Travis Hutt. Are you on?
Dana,
Mr. Hall?
I'm available. I'm just at baggage claim, but I'm in a quiet place. I just can't turn my video on if that's okay.
Perfect. So, Mr.
Thank you.
Hall, would you virtually raise your right hand?
Yes.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, perfect. Mr. Hall, have you been previously qualified by this division as an expert?
I have.
In what field?
Petroleum land matters.
All right, perfect. Mr. Garcia.
Good morning, Hunter. I was looking at your exhibit A7, which is PDF page 38, and I noticed anthracite wasn't provided notice. You have them marked as committed and executed election letter is the reasoning. I was curious why they weren't noticed, but other parties who have the similar statuses were provided notice.
I'm unsure, Dana. We might check if that notice didn't go out, but we've had dialogues with anthracite, prior to this hearing, and since they've executed elections, I think that we would assume that that's sufficient notice, but unsure.
Yeah, because Traverse Exploration has similar status, but they were given notice. I guess that leads me to my second question is, could you explain how an executed election letter would waive their right to notice? Typically OCD accepts JOAs is waiving rights, but how would an election letter do that?
I think for the most part, we just consider them a committed parties. Both of those parties own working interest in multiple other projects with us, and we have no concern about them executing the JOA, nor are we compulsory pulling their interest in this hearing. So I'm unsure if there's any necessary damage that would occur if we didn't improperly notice them. I would defer to Ms. Hardy on our notices.
Okay. Anthracite's aware of this hearing then, to your knowledge?
They are.
And then the last question I had on the same exhibit is ConocoPhillips, you have them listed as committed, and it says type of commitment. It's NA, not applicable. Do you know how they committed?
They have verbally expressed support. We are not pulling their interest as a part of this hearing as we continue to work on either executing a JOA or a transaction, but we're not pulling them for that reason.
Okay. And then I see they were noticed too.
We list them as committed, but it is administrative in the sense that we're not pulling them on the full party list.
Okay. I believe that's all my questions.
All right, thank you, Mr. Garcia. Ms. Hardy, was there any redirect?
No, I just wanted to clarify that the division has required notice to uncommitted parties. And so if parties are listed as committed, it's my understanding under the rules that they are not required to be noticed.
Agree, but it depends on how they're deemed committed, I would say.
Well, let's end that discussion here. Can this case be taken under advisement?
It can.
All right, wonderful. So thank you, Ms. Hardy. Thank you, Mr.
Thank
Hall.
you.
Happy trails wherever you're headed.
Thank you for understanding.
Of course. I'm going to recall some cases that we called earlier before we hit these NOVs. This is Mewburn Oil, case 25746. We had Ms. Hardy, Ms. Bennett, and Ms. Hatley, and we were dealing with a pre-hearing order date.
And Mr. Examiner, thank you. I did consult with Mewburn and with Ms. Bennett, and our clients consulted with each other. And we are fine to set this case for another status conference on March 19th.
Okay. But this case is getting old. So when are we setting it for a contested hearing?
Well, I think we could set it for a hearing in April if the division wants to set a contested hearing, but I think the parties are okay with setting just another status conference.
Can you tell me the date this case was filed?
Yes. It was filed in December, late December.
Okay. All right. So Miss Hardy, I'll honor your request, but it'll be a final status conference.
Understood. Thank you.
So Freya, will you put a note in the hearing module that this will be a final status conference?
I will.
All right, thank you. And Ms. Hardy, you do have dates. We've talked about many dates in April and May for a contested hearing. So please be prepared to give me a date that your client is available. And Ms. Bennett, obviously that I think you were consulting with your client as well.
Yes, I was, and they agree that a March 19th status conference
Okay.
is the best path forward.
Great, then that's what we'll do. Thank you. We're off the record in that case. I'm going to recall Mewbourne oil cases. These are Mr. Bruce's case, 25851 and 52.
Good morning, Mr. Examiner. Ben Holiday on behalf of COG and Concho Oil and Gas.
Okay. Mr. Holiday, Mr. Bruce, did you work out a date?
I'm not sure that he's still on. I have not spoken to Mr. Bruce, but I did confirm with COG Concho that the April 28 date will work.
All right.
If Mr. Bruce is still agreeable to it, obviously.
Right. Thank you, Mr. Holiday. Mr. Bruce, are you there? Freya, can you call Mr. Bruce?
I
Will you
can.
call Mr. Bruce and we'll come back with him on the line?
Okay.
I want him to agree to the April 28 date or not, so that we can issue a pre-hearing order. So we're still in recess on these two cases.
See you in a
but Thank you, Mr. Holiday. We'll see if that date works for Mr. Bruce. Let's call the first of the two Oil Conservation Division's NOV cases. This is 258. Let's go with 25895 because I believe the parties want to continue this case. This is number 26 on our docket.
Thank you, Mr. Hearing Examiner. This is Jesse Tremaine for the Oil Conservation Division. That was going to be my recommendation as well.
Okay, where is the other party?
Good morning, Mr. Examiner. Frank Lyon for Grand Banks Energy.
I see you, Mr. Lyon.
Yes, I mean, I agree with Mr. Tremaine. Yes, we're here to ask for continuance.
So, Mr. Lyon, can you first of all, it's very hard to hear you, so you may have to yell, I don't know. But would you please enter an appearance?
Oh, yes. Frank Lyon for Grand Banks Energy.
Okay, perfect. So, Mr. Lyons, since you're representing the respondent in this case, what is your desire?
Our request is to continue this for a short period of time so that we can finalize the terms of the settlement that Mr. Tremaine and I have worked out.
Aha, okay, so you have an agreement in principle?
We do.
All right, Mr. Tremaine, does that accurately reflect the situation?
That is correct. I agree with everything that Mr. Lyons stated. I would make one note, which is that we have an agreement in principle and have agreed to the continuance. I put in the motion to continue, proposed a specific date. I did that very late in the day yesterday because of the intent to request a short continuance. I did not specifically request availability of Mr. Lyon and his client for March 12th. It's just an initial proposal. So.
All right. Mr. Lyon, does March 12 work for you in case you don't iron out an agreement?
It does. I was just double checking my calendar. It does, yes.
All right. Mr. Lyon, do you anticipate presenting witnesses?
If I do, it'll be very short and just one person.
One person, okay. Would that be the respondent?
That would be a representative from Grand Banks, yes.
All right, perfect. Mr. Lyon, what is the issue in this case?
Well, these notices of violations involve some of the wells that Grand Banks operates, but there are other remediation issues pending. And basically the issue here is that Grand Banks doesn't have the money to pay for all the remediation. And what we have talked about is having Grand Banks basically tender all the money that it has after payment of some taxes and things that need to be paid, and agreeing that the wells, that Grand Banks will give up its right to serve, to be an operator.
I see. Okay, Mr. Lyon. And Mr. Tremaine, it sounds like March 12 will work if you're not able to get an agreement in writing in place.
Yes, that is correct. That's the date we proposed. We will be ready to proceed if it goes to hearing on that date and rely on the previously filed pre-hearing statement and witness list.
And how many witnesses do you have?
3.
3 witnesses. All right. Okay, Mr. Lyons, anything else?
No, sir.
All right. Well, good luck, Mr. Lyon, in coming to a final signed agreement. Mr. Tremaine, anything further in this case?
Nothing further. I will follow up with, assuming we execute a settlement agreement, with a motion to dismiss the case and submit a copy of the settlement agreement.
Perfect. All right. Okay, and I know I didn't see your motion and proposed order before the hearing, but I'll sign the order after the hearing and we'll enter it into the record. And Freya will move this case to the March 12 docket just to hold its place. We're off the record in this case. Let's move on to, now I saw a little message here, so hold on a minute. Let me check the messages here. All right. So let me recall case numbers 258, 51, and 52. Mr. Holliday, we got a message from Mr. Bruce that April 28 does work for him as well.
Perfect.
All right. So we will issue a pre-hearing order for April 28, and it's up to Mr. Bruce if he wants to continue these 2 cases for another status conference, but otherwise we'll be prepared on April 28th.
Yes, sir. Thank you.
Thank you.
Okay, thank you. All right, now let's move on to the second notice of violation issued by the Oil Conservation Division in case number 25894 with respondent Buckeye Disposal. Entry of appearance, please.
Mr. Hearing Exam Officer, this is Jesse Train for the Oil Conservation Division.
Thank you.
Mr. Hearing Examiner, this is Dal Mullenberg on behalf of Buckeye Disposal.
Mr. Mullenberg, I think you were sitting behind me on the way to Dallas last week.
That could have been. I was Saturday,
No,
perhaps.
it was Wednesday. You were traveling to Tampa. I happened to overhear.
Oh, okay. Actually, that was my neighbor in the seat that was traveling to Tampa. I was traveling to New York City and was lucky to get out of there on Saturday.
All right. Well, I heard what sounded like it was you behind me, and I didn't introduce myself, but I thought I would mention it. Okay.
Well,
So
I should have recognized you.
Mr. Mullenberg, who are you representing?
Mr. Hearing Examiner, I'm here on behalf of Buckeye Disposal.
All right, perfect. And are you prepared to move forward with the merits hearing?
Yes, we are. I think we probably would be interested in seeing if we can get to some resolution afterward. But I think we're prepared to go ahead with the merits hearing, and we'll deal with that after this concludes.
All right. And how many witnesses will you have?
We do not have any witnesses.
Okay.
I'm just here to ask some questions
Okay.
of the division's witnesses.
Perfect. Okay. Do you want, I'm going to give Mr. Tremaine an opportunity to provide a brief opening statement so that I can understand the issues in the case. Are you going to want to also make an opening statement?
I can make a very brief opening statement if it pleases you. Thank you.
All right. Mr. Tremaine, it's your case. Would you tell me how many witnesses do you have?
We have 3 witnesses, and for the most part, my opening will be a roadmap of how we intend to present them. This is the first Part 29 release notice of violation that we've taken to hearing. All of our others have settled. So our first witness, Mr. Smith, is going to basically provide a Part 29 requirements roadmap and 101 course. Our primary witness is Brittany Hall, and she will present, the factual basis and the allegations in the NOV and civil penalty calculator primarily. And batting cleanup is Rosa Ramiro, our environmental bureau chief, is going to talk about the informal resolution process and to a minimal extent, and OCD's positions and decision-making process regarding which violations were alleged, decisions regarding the civil penalty calculation, et cetera. So I think Mr. Smith may go about half an hour. Ms. Hall could be, I'm hoping less than an hour, but depending on questions, that could go quite long. These are long fact patterns, just historical releases, et cetera. And then Ms. Ramiro should be fairly short. I would just note, in terms of just as a matter of courtesy, I know that Mr. Mullenberg was in Pecos Hall on the other matter this morning and is transit back to his office. So I'm flexible in terms of timing of starting the hearing to facilitate that, his participation, but we're prepared to proceed as the hearing officer wishes.
All right.
Mr. Examiner, just to comment on that, and I was hoping perhaps this would run a little bit shorter, and we are occupying Pecos Hall with the Environmental Improvement Board hearing. This has sort of been a worst case scenario for me in terms of timing.
Right.
We're actually presenting our witnesses now through my partners, but I'm just trying to think how to deal with that. I'd certainly like to return to that hearing, but I expect that's going to run for another hour, hour and a half.
At least.
So, yeah.
Yes, I know the rulemakings, how they go. Yeah, I'd like to move forward now. Let me ask you a question, Mr. Tremaine. These 3 witnesses, Smith, Hall, and Romero. I know Ms. Romero is an employee of the Oil Conservation Division. Is that the same with Smith and Hall?
That's correct. Mr. Smith is the Special Projects Team Supervisor. He's an environmental scientist supervisor who reports directly to Ms. Romero. And Ms. Hall is a supervising environmental specialist.
Okay. Now, did you file CVs with with your pre-hearing statement?
Yes, we filed a CV for Mr. Smith. We do intend to proffer Mr. Smith as an expert in limited subject matters. Ms. Hall is presented as a fact witness, but we have provided her resume. And Ms. Romero, we've also provided a resume as Exhibit 5. I will, if it's helpful, we elected to file written direct testimony as Exhibit 2 for Mr. Smith and written direct testimony as Exhibit 4 for Ms. Hall. My intent is to have those witnesses adopt that and then take a more summary approach. Just the scope of the subject matter and needing to make sure we have our bases covered. There's a wide range of how long that presentation and cross-examination could proceed. So that's my conservative approach to the time estimates.
All right. Mr. Molenberg, have you had a chance to review the exhibits and the pre-hearing statement?
Yes, I have, Mr. Hearing Examiner, and I have no objection to the process of admitting the adopting and admitting the written testimony and shortening the need for the oral hearing if that's how you would like to go.
That is how I'd like to go, unless Mr. Tremaine objects to that approach. Mr. Tremaine, Mr. Molenberg has reviewed the full written transcript, and maybe a short summary, 10 minutes, possibly 15, should do it. Don't you think so?
I think I can certainly narrow that down and jump to the meat of the questions. I never know if there's going to be an objection, so we were prepared to go all the way through. I think the most important distinction here is, whether there are any exhibits to which Mr. Molenberg would object. I know he just referenced the direct. It can be quite time intensive to get Ms. Hall to lay the foundation for 20 some exhibits. So if there's no objection to those and the other exhibits can be admitted, that will save us quite a bit of time.
It certainly would. And Mr. Molenberg, I know that you're in a car. However, you're parked, aren't you?
I am parked. I'm sitting outside of the building here.
Yeah, I figured you were right outside the building, and it's a beautiful day outside. So, with the windows open, you should be comfortable. Are there any objections to any of the exhibits that the Oil Conservation Division has filed in this case?
No objections.
That's what I thought. Mr. Tremaine, all your exhibits are admitted into evidence. Now, the only thing I would like to hear from your witnesses is that they adopt them under oath, and if there are any corrections that need to be made, I'd like to hear about those corrections up front. And then maybe a 5-minute summary of what these exhibits are showing would be helpful to me. Before we go to cross-examination and then redirect if necessary. So why don't you go right ahead?
Great. Well, we're talking about a notice of violation today that relates to 2 historical releases, initially occurring in 2016 and 2018. As we've discussed at some length, the fact patterns are quite extensive. Our OCD exhibit binder is close to 600 pages. We really went belt and suspenders with that, so we're going to try to be very circumspect here. But one note real quickly, the OCD ultimately determined after a series of Environmental Bureau interactions with the operator that an NOV was necessary, and that was issued in April 3rd, 2025. Respondent Buckeye was served and accepted receipt of that NOV, and the parties have been in informal resolution since April 2025, on and off, primarily technical discussions. We've kept the informal resolution open that long in hopes that Buckeye would be able to complete the necessary remediation activities, but we have seen a shift in OCD's approach to the NOV around the time of docketing, because in December, OCD became informally aware that Buckeye was not expecting to be able to complete the required activity under Part 29, which I believe is now acknowledged formally in respondent's pre-hearing statement. So given that posture and operators' inability to complete the remediation activities, OCD prepared the presentation today, intends to present those facts and request an order finding that Buckeye is in violation of the reference rule sections, imposing the civil penalties as proposed, and granting OCD authority to complete all of the necessary plugging, remediation, and reclamation. That's notable. We usually would not ask for plugging orders on the basis of an environmental remediation violation, but with the awareness that Buckeye expects to be incapable of completing that remediation, that becomes necessary. And OCD would expect, as a result of an order or settlement agreement in this case, if that is to happen, that OCD would be utilizing the reclamation fund to complete any plugging and associated remediation reclamation activities. So that is a distinction to make about this, and noting the specific both sanctions and remedies requested. With that, I would call Corey Smith as our first witness.
Can we have all three of your witnesses on the screen at the same time? I'm going to get them all sworn in.
I believe all three are available. Is Brittany Hall, okay, and Rosa Romero, can you please pop on?
I'm here.
Okay. Good morning, Mr. Smith, Ms. Hall, and Ms. Romero. Would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
Okay, I heard three I do's. Mr. Smith, would you spell your name?
Corey Smith, Corysmith.
Okay, and Ms. Hall?
Brittany Hall, Brittanyhall.
Thank you. And Ms. Romero?
Rosa Romero, Rosaromero.
Okay, thank you. I'm going to continue now with Mr. Smith. So, Mr. Tremaine, you said you would like to have Mr. Smith qualified as an expert in a certain subject matter. Can you tell me more about that?
Yes, Mr. Smith has extensive experience in the oil and gas field, generally as an environmental specialist and the supervisor of the special projects groups overseeing the work of environmental specialists. So we're offering Mr. Smith as an expert in the areas of administrative implementation of Part 29 and the OCD incidence system. Mr. Smith was primarily responsible for structuring a host of updates to that system and is extremely knowledgeable in both the administrative requirements of Part 29 and specifically how operators are expected to and are able to provide updates regarding incidents through OCD's electronic permitting system.
Okay.
That's
Now,
largely the subject. Go ahead.
Thank you, Mr. Tremaine. Which document am I looking at to find his CV? Because I see 3 documents filed on the 20th, one on the 19th. Which is it?
I'm not sure about those dates, but in the OCD exhibit binder for this case, Mr. Smith's CV is exhibit 1.
It's the middle. It's the middle image, Gregory. Second from the right.
Thank you. Second from the right. Thank you. Okay, and I see it.
Entire
yes,
OCD exhibit packet.
Thank you, Mr. Garcia. Okay, Mr. Smith, let me just review your CV. Mr. Molenberg, have you seen the CV?
Yes, I have, Mr. Hearing Examiner.
Okay. Do you, is there any objection to qualifying him as a limited expert in these fields?
No objection.
No objection. All right. I see relevant experience going all the way back to 2004. And I'm not going to go through it. There's no objection to Mr. Smith being admitted as an expert in the fields that Mr. Tremaine just listed. And I see substantial evidence that would lead me to qualify him in any event. So that's granted, Mr. Tremaine. So do you want to go on now with a summary? I do see Mr. Smith's direct testimony in here. He is sworn in, so do you want to go on?
I will. Thank you, Mr. Hearing Officer. Mr. Smith, you prepared direct testimony in preparation for this hearing, which is listed as OCD Exhibit number 2, correct?
I did.
And today, are there any corrections that are necessary to make to that direct testimony to the best of your knowledge?
Not that I'm aware of.
Okay, and do you adopt that written direct testimony as your sworn testimony today?
I do.
Okay, great. We've already admitted all of the exhibits, so Mr. Smith, I'm just going to jump right to referencing exhibits number 26, 27, and 28. I'm going to take these out of order. And Mr. Hearing Examiner, I'd like to share screen here. I'm going to share OCD exhibit number 27. Mr. Smith, could you please describe for the hearing examiner and the parties the information that's contained on this slide and the significance of this information?
So this is essentially just a visual representation of the incident timeline that generally happens with incidents that are related to Part 29. Moving left to right at the very top, generally speaking, incidents are discovered and they're generated with a date of release or a DOR. And then the first box there is operators need to make a decision if this is a major or minor release based on volumes, or if the incident has a fire or potentially enters a waterway, other hazard. Right, so they need to define if it's a major or minor release, because the difference is that if it's a major release, they need to provide notice to the OCD within 24 hours of the date of the discovery. And if it's a minor release, then they just need to fill out the initial C-141 within 15 days.
Mr. Smith, let me interject with a question there. What is the volumetric threshold for a major and minor release, respectively?
So a major release is any release that is more than 25 barrels of a substance or 500 MCF of gases. And a minor release is 5 barrels and 25 MCF, or excuse me, 50 MCF.
So please proceed with describing the content of this timeline as it applies to major or minor releases.
Right, and so what I'm trying to just show here is that there's essentially the first step, the first requirement is that you have to, one, provide notice to OCD either within 24 hours and then within 15 days by submitting an initial C-141. After that, the operator essentially has two different choices. They have essentially 90 days from the date of discovery to either do the top path, which is a formal delineation. That's where operators perform site delineation vertically and horizontally under 1915-2911. And then they submit a remediation plan for review to the OCD. The reason that the bottom right-hand part where it says variable timeframes for both of these steps is because when you submit a formal delineation, you're allowed to ask for additional time. So it's not necessarily just 90 days, but the remediation plan has a requirement that the operator provides the OCD a proposed timeline for approval. If they choose the bottom path, which is generally the path that most operators go for smaller sites, they complete site characterization, they complete the remediation plan and the remediation within 90 days and submit that to the OCD for approval. Once moving left to right, once those are approved and remediation is complete, the next step is site reclamation. That generally involves the meeting the reclamation requirements of 1915-2913, which is in the top 4 feet. Again, why this is variable is because some parts of a release may not be reclaimed until the pad, until the P&A, or sorry, excuse me, until the well is P&A'd, which could be decades, as we all know, because those areas may be reasonably needed for subsequent drilling or workover activities. Once the site's been reclaimed, the next step is revegetation. Again, the requirement is that it's revegetated in the next favorable growing season after it's been reclaimed. As you all are aware, we live in the southwest part of the United States, and sometimes the weather is not favorable for growing, and it can also take long periods of time. So that is also a variable time frame. Once the operator completes revegetation, the OCD considers the incident to be restored and restoration is complete, and there's no further action needed.
Mr. Smith, I've got a couple clarifying questions while you're at that. First, in terms of the timelines, is it fair to summarize that the default deadline to complete a remediation is 90 days?
Yes.
Okay. And that deadline would apply in the absence of an approved remediation plan submitted by the operator. Is that correct?
Yes.
Okay. And just clarifying here, connecting some terminology. You indicated that a notice may be required for major releases within 24 hours. Is that in the upper left here, is that what's referred to as an NOR?
Yes.
Okay. And how is an NOR submitted to the Oil Conservation Division?
NOR is submitted through the NOR application on the OCD permitting website.
Okay. And the subsequent submission or report notification to OCD for a minor, is that what's referred to here as the initial C-141?
Yes, sir.
Okay. I just want to make sure we're connecting the dots to the form types. Is that also submitted through the OCD permitting system?
Yes, sir.
Okay. Any other clarifications that are necessary, in your opinion, on those form types or process?
Just for Mr. Hearing Examiner, each application that's submitted through OCD permitting gets a unique application ID number, and it's displayed in the incident timeline and the incident details.
So, Mr. Smith, jumping forward as we're talking through this timeline, if OCD were to allege a violation of an initial notification requirement, are we referring to that 24-hour NOR or notice of release?
Can you repeat your question, Mr. Tremaine?
Yeah, so in the event that the OCD alleges that an operator violated the requirement to submit a 24-hour notification, is that notice of release that we just discussed?
Yes, sir.
Okay. And if OCD alleges a violation that an operator failed to submit subsequent report of a release, does that refer to the C-141 that we've discussed?
Yes, sir.
Okay. Is there, I jumped in with clarifying questions. Was there any other information that you wanted to share with the hearing officer from this slide?
The bottom section is just overview of the different statuses based upon the different type of C-141s that are submitted. So the C-141 has multiple choices, and it's all based upon how the operator answers the questions as to what type of C-141 it is. And the bottom boxes down there kind of tell you which one that is and which status those incidents are in as you move left to right.
Great. Thank you. I think I think we've covered that slide, so I will move on to OCD exhibit number 28. Mr. Smith, what is OCD exhibit 28?
OCD exhibit 28 is just a PowerPoint essentially showing the major release notification example that the OCD receives when we when the operator completes the NOR application. This is just an example of what we see and who it goes to. So it goes to the environmental bureau chief, the environmental incident supervisor. It also goes to the environmental field compliance supervisor. And the major notice, it has the application ID, the operator's OGRID, the incident number, and allows us to quickly follow up if we need to.
Mr. Smith, let me interrupt you for a moment. Mr. Tremaine, I wonder if this wouldn't be more streamlined if we found out what the respondent was challenging. I understand why you're doing this, and it's not wrong, but I wonder if we need to spend time on this if the respondent's not challenging. So, Mr. Molenberg, what part of this case is your client challenging?
Thank you, Mr. Hearing Officer. My client's not challenging the overall case. We do think there are some important factors that are involved in terms of particularly the penalty assessment, including evidence of historic incidents or releases that preceded the incidents that have led to the NOV, including by prior operators and operators of other facilities in the vicinity. A factor in this particular case is that the state land office is involved as the site is under a state lease. So there's sort of two tracks to this matter. There's one issue in particular, I think, related to the penalty assessment, which is a period of time where communications were interrupted by the COVID incident. This is a pretty long-standing matter.
So, Mr.
And
Molenberg, let me interrupt you for a
yes.
moment. I think I understand where you're going here, and I
Yeah.
think, correct me if I'm wrong, your client is not challenging whether there was a violation. Your client is admitting there was a violation?
That's a little bit of a complex question under a complex set of circumstances. So probably sounds like I'm kind of dodging that question, but I would concede that there is evidence that the timelines specified in Part 29 were not met during certain periods. Now, of course, there is the COVID piece. There's a time where I think the record shows that communications were interrupted, and that does factor into a penalty assessment here. I think, given we're running penalty assessments over some of that time frame, that's a matter. But at the heart of the matter here is, as Mr. Tremaine indicated, Buckeye Disposal for some time attempted to and has done a lot of site characterization work. As sometimes happens with site characterization work, you collect soil samples. That indicates that maybe things are more than were originally anticipated, or there are contaminant sources other than the incidents being addressed. And along with that, Buckeye Disposal was submitting proposed remediation plans, which it hoped to have the means to carry out. But essentially, as this case progressed, Buckeye no longer has sufficient resources to complete characterization and to conduct remediation within the scope of what the division believes is necessary. So that's a summary of where we're at. I don't know if that clarified the issues or muddied the waters for you, Mr. Hearing Officer, but that's essentially the narrative that I would present here.
It sounds like what you're saying, and I'm going to go to you in a moment, Mr. Tremaine. I've seen your hand up. It sounds like what you're saying to me, Mr. Molenberg, is my client's willing to accept a certain amount of responsibility, but we feel like the penalty is too high.
I think that's a fair assessment.
Okay. Mr. Tremaine, what were you going to say?
Well, I was going to say that, yeah, without knowing ahead of time that whether there was a dispute regarding the specific timelines, because these various timelines attach all the way back to 2018. We've prepared this presentation. If that's not necessary, I can move on. Ms. Hall is able to speak to the particular status of site characterization work, incident statuses at those two sites. We're going to use both her and Ms. Ramiro to talk about the civil penalty calculation. Relative to, I'd ask for a moment of grace and patience because I'm asking my witnesses to move through their presentations out of order, but I can move to Ms. Hall to address those two questions. I'd ask her to adopt her direct testimony and then provide a summary of the incidents, and then we can get into those two questions if that pleases the hearing officer.
Let's do this. So, Mr. Molenberg, Mr. Smith has adopted his written testimony under oath, made no corrections to it. Do you have any questions for Mr. Smith?
I do not have any questions for Mr. Smith. I understand he is the witness that's kind of presenting the Part 29 treatise, so to speak, and not so much the particular site issues.
That's what I understood that too, and I felt like you probably didn't have any issue with his testimony and you weren't going to be cross-examining him. And so we didn't need to spend a bunch of time since we've already gotten his information in evidence with your stipulation. So, Mr. Smith, thank you for your participation. Mr. Tremaine may recall you. I don't know what's going to happen, but thank you for your work in this case.
Thank you.
Okay, Ms. Hall, Mr. Tremaine was addressing you.
Thank you. Yeah, I think you indicated this, Mr. Hearing Officer, but that would be my only stipulation with moving on is that if there's a clarification on those process requirements and deadlines, I may need to go back to Mr. Smith. I don't expect there to be. Ms. Hall, we've entered the exhibits, but I just want to direct you to OCD exhibit number 4. Did you prepare, OCD exhibit number 3, is that your resume which you prepared in preparation for this hearing?
Yes.
And there's no corrections are necessary to that exhibit, are there?
No.
Okay. And did you prepare written direct testimony, which is OCD exhibit number 4?
Yes.
Does OCD exhibit, does your direct testimony require any corrections or changes today?
No.
Is the information that you provided in your direct testimony true and accurate to the best of your knowledge?
Yes.
And do you adopt your written direct testimony, exhibit 4, as your sworn testimony today?
Yes.
Okay. I'm going to jump right to asking you, so I think to be clear, there's 2 incidents that are referenced with proposed violations in the NOV, correct?
Correct.
Could you please provide us with a brief summary of the nature of the releases and their current statuses?
So both releases were reported at the state AF number 3 by Buckeye Disposal. They're historic in nature, just simply meaning that they were discovered in 2018 or prior to 2018, and they're still actively open in the OCD's system. The incident event notes state that both of the releases were actually discovered by state regulatory bodies and not the operator themselves. But they also indicate on the initial C-141 that was submitted by the operator that they both occurred within the dike of the line tank battery. As of right now, there's not enough information for OCD to determine if they overlapped each other or not.
Ms. Hall, did you hear the discussion earlier regarding the suggestion that Buckeye has completed some substantial site characterization work at the site?
I did.
Okay. I'd like you to summarize OCD's response to that and just give an outline or briefing for us on what delineation and characterization records or information does OCD have regarding those two incidents? That was a little compound. Do you understand my question?
Kind of, but can we break it down into separate?
Yeah, let me rephrase. So we referred to the site characterization work. So what's the status of the delineation stage at each incident?
So each incident, I would say delineation is not complete. Buckeye Disposal has completed some soil sampling and an EM or electromagnetic survey of the sites, indicating that there is contamination in the ground that is above OCD's closure criteria. But as of this hearing, OCD has not received complete vertical delineation of the site. And
Okay,
that would include,
go ahead.
I was just gonna say that would include information for both incidents.
Okay, so what specific information is, in your opinion, missing from the delineation reports that have been submitted?
The specific information that I would say is missing is full delineation of the site. We would need vertical delineation for, I believe, just petroleum hydrocarbons. And we would also need a remediation plan that we could approve based on that delineation.
Okay, so I asked you about delineation. Is site characterization work complete? What's the status of that?
The site characterization work includes the delineation, so it is not complete.
Okay. Anything about site characterization specifically that's missing or required under Part 29, which we did not already discuss as part of the delineation?
I don't believe so.
Okay. You did reference an approvable remediation plan. What's the status of Buckeye's, any remediation plans submitted by Buckeye?
So in the remediation plans that Buckeye has submitted recently, I would say like within the year of 2025, they are proposing to either excavate at one point just the upper 4 feet or excavate down to 5.5 feet and place a clay liner. The location of the releases have sensitive setbacks that would put the operator into needing to remediate to the most stringent closure criteria. And the upper, 4 and 5 feet, unfortunately, aren't the only strata of soil that are contaminated.
Okay, so is it fair to say that the issues with the remediation plans are the Part 29 remediation standards?
I would say that's fair.
Okay. Buckeye is proposing to remediate to the least stringent standard, but OCD is requiring Buckeye to remediate to the most stringent standard?
At one point, Buckeye was proposing to remediate to the least stringent closure criteria based on depth to water in the area. Depth to water in the area is over 100 feet, but they're within 1,000 foot of a water well, which automatically puts them in the most stringent closure criteria, as well as there's a freshwater pond just south of the site. And so they're within the setbacks of that as well, just based on some delineation points that they have. The issue with only remediating the upper 4 to 5.5 feet is that would require the OCD does not approve a variance without full delineation.
Thank you. Is there anything else regarding the status of these two incidents that we need to discuss that I haven't asked you about related to the reference site characterization work generally?
I don't believe so.
Okay. So I'd like to move along and talk through OCD exhibit number 10. This is the civil penalty calculator. This has been admitted, and I'm going to share screen. Pardon, these are very wide documents. So I'm going to try to get this on the screen here. All right. So, Ms. Hall, were you directly responsible for preparing the draft NOV and civil penalty calculator?
I was.
Okay. And to clarify, is that NOV subject to and civil penalty calculator subject to approval by your supervisors and OCD leadership?
It is.
I want to run through here and just ask you to connect the dots between the line items in the civil penalty calculator and the violations that are alleged in the NOV. And I'd like, let's start with the first line here, the 29.8A violation. I believe that you heard Mr. Mullenberg's statement regarding violations that have been assessed at different periods of time, preceding periods of time. Is it consistent with your understanding that Part 29 and Part 5, the enforcement rule, have been updated after these two incidents initially occurred?
Yes.
Okay. So here on this first line, we've cited proposed a violation, a single day violation for a prohibited minor release. Could you please describe why OCD proposed a minor release violation?
So we proposed the minor release violation. We proposed it as a minor due to the fact that when Buckeye submitted their initial C-141s for each of the incidents, they indicated that the release did not exceed 25 barrels. And so that would put it in the minor category. We also proposed it as a one-day violation because the well has been plugged. I believe it was plugged in April of 2023. But since the release has not been remediated yet, we imposed a one-day fine.
And would you agree with me? Well, I'll strike that. So that release, when was that release reported to have occurred initially?
Are you asking the date of discovery?
The date of discovery, yes.
So there's two separate releases on the civil penalty calculator. The first release was discovered in 2016. I can't remember the month. And then the second release was discovered in 2018.
Okay. And that release, that first release, 2016, I believe you already testified that it is not yet remediated, correct?
Correct.
Okay. And would you agree with me if I said that in 2016, OCD did not have civil penalty authority or the had not prohibited major or minor releases?
Yes, I would agree with that.
Okay. Does OCD consider this to be an ongoing violation?
Yes.
Okay. And would the fact that the incident is not remediated, would that be adequate grounds for proposing a different violation for failing to remediate a release under another section of Part 29?
Can you repeat that?
Yes. Alternatively to proposing a minor release violation, could OCD have proposed a violation for failing to remediate the release.
Yes.
Okay. And that violation, could that have been proposed as a multi-day an ongoing violation?
Yes.
Okay. I want to move on to the second one. Again, we're on the first incident here, 2016, the 2911. Which violation does this relate to?
I believe that's failure to submit site characterization, but it's pretty small.
And is that one of the C-141s that we've referenced through Mr. Smith's testimony?
Yes, it is a portion of the remediation plan C-141.
Okay. I specifically want to ask you if there's any clarifications that you need to make in terms of how OCD proposed this line item civil penalty.
Yes, there is. So the day of violations for that particular violation that we are talking about is listed at 2,250 days. I calculated that violation based on the transitional clause of 1915-29, which essentially gave the operators 90 days to submit a remediation plan with site characterization after the new rule came into effect. The days penalized in the orange column is incorrect. That should be a penalty. Days penalized should be 252 days, which would be the date from the last extension request due date that Buckeye submitted.
Okay. So to clarify, this days in violation, that total number of days, that goes back to 2018, correct?
Correct.
Okay. And we've covered this, but in 2018, OCD didn't have civil penalty authority under Part 5, right?
Correct.
Okay. So if we change this to 252, what event or deadline does that 252 day calculation relate to?
I'm sorry, I didn't understand that question.
Yeah, you indicated in answer to my previous question that 2,250 days penalized should be 252 days. What is that 252 days attached to?
That is attached to the last due date that the OCD gave as an extension request.
Okay. So this second line item in the civil penalty calculator maxes out at the $200,000. If we update the civil penalty calculator in the days penalized column to 252, does that change the total proposed civil penalty in this total column?
It does not.
Okay. There are a number, before we get into just connecting the dots and specific violations, there's a number of these 2,250 days in here. Does the same analysis apply to those other line items?
It does.
Okay. If we update those other line items to violations only occurring in 2023 through 2025 in that time period, does that change the total calculated civil penalty?
It does not.
Okay. And did you test that assumption or run new civil penalties in preparation for the hearing?
I did.
Okay. All right. So after you change those days penalized dates, do you still get a proposed civil penalty of $1,604,500?
Yes.
Okay. Thank you. So that, Mr. Hearing Examiner, I think that is going to cover our direct portion regarding the clarifications on the civil penalty calculator. If necessary, I'm happy to walk through and talk about the nature of the violation in each line item, but I'm expecting that the concerns with the proposed civil penalty and the calculators relate to the specific items that I brought up.
Okay, so you offering Ms. Hall for cross-examination?
Yeah, in order to expedite this process, yes. If there's questions about the nature of the other violations, I'd like to come back, but
Okay.
I think good faith effort to move this forward.
Perfect. Mr. Molenberg?
Thank you, Mr. Hearing Officer. Good morning, Ms. Hall. Thank you for your testimony here today. I have just a couple of questions. In the chart that you presented, is there a period of time covered by the history there that was during the COVID epidemic?
So I believe with the 2,250 days in that penalized column, it probably would cover a portion of the COVID epidemic. But again, we're changing, that was a typo, it's incorrect. The 252 days actually is calculated from May 2nd, 2024, I believe. I know it's May 2024. I can't remember if it's the second or the first.
Okay, thank you for that. And aside from that original 2000 and such day period, is there any other portion of the timeline covered by the proposed civil penalty that was during the COVID period of roughly March of 2020 until probably sometime in 2022 when everything was fully up and running again?
No.
Okay, thank you. Ms. Hall, earlier in your summary, and I know you've given a very abbreviated summary, you mentioned electromagnetic survey work performed by Buckeye Disposal. Do you recall that?
Yes, sir.
Has Buckeye Disposal also completed a number of soil borings, obtained samples for analysis, and provided the results of the analytical sampling?
I believe so. I think there may be one set of samplings that wasn't submitted with the remediation plan due to the NOV, but I can't recall off the top of my head if that one was submitted or not.
Okay, and I believe you've included Buckeye Disposal's proposed plans and reports in the record. That additional work that I'm mentioning would be shown in there?
Correct.
Okay. Would you agree with me that in Buckeye Disposal's various plans that it identified issues that indicated that there may have been historic releases at this site that preceded the incidents that you've identified as the basis for the NOV?
I wouldn't be able to speak to that since no other releases has been reported to the OCD by separate operators.
Is it your understanding that there were and may continue to be other operators operating at or in the vicinity of this site?
Yes.
And as to my earlier question, any such information regarding other potential historic releases, reported or not reported, would be indicated in the Buckeye Disposal written submissions to OCD?
I would say yes, I agree that Buckeye has indicated that other operators may have had releases in the vicinity.
Thank you, Ms. Hall. That's all I have.
Thank you.
So I'm going to ask Mr. Garcia, our technical examiner, if he has any questions for Ms. Hall.
I believe I have two, maybe. Ms. Hall, Mr. Molenberg was kind of asking about COVID. You stated that 252 days is before COVID or after COVID. I guess my question is, even in regards to COVID, did the division issue any clarifications for spills during the COVID timeline?
I was not a part of the division during the COVID timeline, so I'm not sure. Other than I believe at some point in time,